Welcome to The Explainer. Today, we're diving into a landmark legal battle, one that's putting the biggest names in social media right in the hot seat, with a jury ready to decide their fate.
And really, it all boils down to this one central question. It's a question at the heart of a whole wave of lawsuits that could fundamentally change the internet as we know it. And for the very first time, that question is being put directly to a jury. Right now, in a Los Angeles courtroom, a trial is kicking off that pits these huge social media companies against claims that they knowingly design their platforms to get young users hooked, causing some serious mental and emotional harm along the way.
Okay, so let's get right into it. To really wrap our heads around what's happening and what's at stake, we first need to meet the key players in this high-stakes legal drama. So on one side of the courtroom, you've got the plaintiff, a teenager identified as KGM, and she's not alone. She's backed by a coalition of over 1,000 other plaintiffs. And on the other side, the defendants. You've got industry giants Meta, which of course owns Facebook and Instagram, and Google, which owns YouTube. But you know what's really interesting here? It's who you don't see on that list. Both TikTok and Snapchat were originally named as defendants, but they settled out of court right before the trial was set to start, leaving Meta and Google to face the jury all by themselves. So what are these companies actually being accused of? Let's break down the specific arguments at the very heart of the plaintiff's case. The whole case is really built around these powerful, personal stories, like the one from KGM. She claims that her nonstop use of these apps, which started when she was just 10 years old, led to severe mental health issues. We're talking depression, anxiety, and body dysmorphia. That's a really tough condition where you become obsessed with perceived flaws in how you look. In her own words, she says it basically robbed her of her childhood. And her story is really the launchpad for a much bigger argument. See, the lawsuit isn't just about the content on these apps. It's targeting the very design, the architecture of the apps themselves. The plaintiffs are arguing that features we all know, the infinite scroll, the autoplay videos, those constant notifications, they weren't accidents. The claim is that these things were put there on purpose, engineered to make the platforms addictive and almost impossible for kids to put down. So the legal team for the plaintiffs? They think this trial is going to be a massive moment of reckoning. Their lead attorney, Matthew Bergman, is basically saying this trial will finally pull back the curtain on internal company secrets. Things like emails and research that they believe will show a jury that these companies knew about the potential harm, but chose profits over the well-being of their youngest users. And this is where their whole strategy really clicks into place. A lot of people are drawing a direct line from this case all the way back to those historic lawsuits against Big Tobacco in the 90s. I mean, the parallels are pretty striking, right? In both cases, you have an industry accused of knowing its product was harmful and addictive, and then trying to cover up that knowledge to keep the money rolling in. Okay, but this is a legal battle, not a lecture. It is definitely not a one-sided story. The tech companies are pushing back, and they're pushing back hard. So let's take a look at how they're building their defense against these really serious claims. So the companies are firing back on all cylinders. First, they argue there's no solid scientific proof of a direct link between using social media and developing mental health problems. They also point out that social media addiction, as a term, isn't actually an official clinical diagnosis. And on top of that, they're highlighting the millions of dollars they've invested in safety features, like parental controls and time limits, all designed to protect teen users. And a huge piece of their defense, maybe the most important piece, is a controversial law called Section 230. For a long time, this federal law has basically been a legal shield for online platforms, protecting them from being held liable for what their users post. Now, the plaintiffs are trying to get around this by focusing on the design of the product, not the user content. But Section 230 is still a really powerful shield for these tech giants.
Yeah, so to make this a little easier to understand, legal expert Eric Goldman uses this great analogy. He says the plaintiffs are trying to treat social media platforms like they're a defective physical product, like a soda bottle that explodes and hurts someone. Goldman's point is that this comparison just doesn't work. You can't apply the same legal rules for product liability to a media platform that you would to a physical object.
And as you'd expect, both Meta and Google have put out official statements saying these lawsuits are just plain misleading. They claim the cases cherry-pick internal documents and quotes to paint a false picture, totally ignoring all the work they do to create safe and positive online spaces for young people. Okay, so why should you care about one trial in a Los Angeles courtroom? Well, because the outcome here matters to all of us. The stakes are incredibly high. See, this case is what lawyers call a bellwether trial. It's just the first one to make it in front of a jury, but there are over 1,000 other lawsuits, from regular people, from school districts, even from state attorneys general, all waiting in the legal pipeline. Whatever the jury decides here is going to send a huge ripple effect and could shape how all of those other cases turn out.
And that brings us to this quote from legal expert Eric Goldman, which just perfectly sums up how big this is. He's warning that this isn't just about Meta or Google's stock price. The very rules of the internet, how platforms are built, what they're on the hook for, all of that is being put to the test.
Think about it. If the plaintiffs win, it would be like an earthquake hitting the tech industry. It could force companies to completely redesign their platforms, and that could lead to an internet that's a lot less interactive, a lot less conversational, and yeah, a lot less engaging than the one we have now.
Now flip that coin. If the companies win, it would reinforce those legal shields they have right now, like Section 230. But it almost certainly wouldn't be the end of the story. You can bet that the public pressure and the pressure from lawmakers to regulate these platforms would only get louder.
And this really gets to the heart of the paradox we're all living in, right? It leaves us with this final, really tricky question. The very same features that make technology so compelling and useful are the exact same ones now being accused of causing harm. So where do we draw the line? What's the right balance? And maybe the biggest question of all, who gets to decide?